This week at the Supreme Court. The Judicial and Bar Council, or JBC, has announced the opening for application or recommendation of the position of Supreme Court Associate Justice to take the place of Honorable Mario V. Lopez, who will compulsorily retire on June 4, 2025. The deadline for the submission of online applications through the JBC online registration and application system is on March 28, 2025 at 4:30 in the afternoon. The Court en banc in Bar Matter number 4261 has ordered to defer the implementation of the prohibition on government lawyers from becoming chapter officers of the Integrated Bar of the Philippines, or IBP, for another term or until 2027. This prohibition is stated in Section 4 of the IBP's revised bylaws. The court emphasized that government lawyers are prohibited from serving as chapter president and from holding more than half of the total officer positions in IBP chapters with no more than 100 members. But the following government lawyers are still prohibited: presidential appointees, national government or government-owned and/or controlled corporations officers with salary grade 26 and above, local government unit officers with salary grade 25 and above, elected officials, prosecutors, and those employed in the judiciary or quasi-judicial bodies. The Supreme Court has ruled that officers and directors of electric cooperatives are not automatically deemed resigned upon filing their certificates of candidacy or COCs for local and national elections. In a decision written by Associate Justice Japar B. de Maampao, the Supreme Court's Third Division nullified Section 2 of National Electrification Administration, or NEA, Memorandum Number 2012-2016, which mandated that officers of electric cooperatives be deemed resigned upon the mere filing of their COCs. Under the Omnibus Election Code, automatic resignation upon filing of COCs applies only to persons holding public appointive positions, including active members of the Armed Forces of the Philippines and officers and members of government-owned or controlled corporations. This ruling stemmed from a case filed by Oscar C. Borja and Venancio B. Regulado, former members of the Board of Directors of Camarines Sur Electric Cooperative II, who challenged the validity of Section 2 of the NEA Memorandum. Borja ran for mayor of Bombon, Camarines Sur, while Regulado sought a seat in the Canaman Municipal Council. In another case, the SC has emphasized that a contract of sale of goods is completed by a mere agreement between the parties, even without a written document. In A Ponencia by Associate Justice Henry John Paul B. Inting, the SC's Third Division directed Marcelina Villanueva to pay Coca-Cola bottlers Phil's Inc. over 600,000 pesos for unpaid products delivered under their dealership agreement. Coca-Cola claimed it had a dealership agreement with Villanueva, but she denied knowledge of the dealership agreement, claiming it was her nephews who actually managed the business and that they should be held liable instead. Ruling that Villanueva is liable to Coca-Cola for the entire unpaid obligation, the Supreme Court held that while no written contract was presented, the sale of goods was proven through other evidence, such as signed delivery invoices confirming the purchase, payment terms, and actual delivery of the products. The Supreme Court has also reiterated that a notice to cancel a contract to sell real estate must be notarized under Republic Act No. 6552 or the Maceda Law. In a decision written by Associate Justice Antonio T. Go Jr., the SC's Second Division upheld the validity of contracts to sell between State Investment Trust Inc. or SITI and spouses Carlos and Victoria Baculo after SITI failed to meet the Maceda Law's cancellation requirements. SITI had sold 2 parcels of land in Batasan Hills, Quezon City to spouses Baculo through 2 contracts to sell, payable in installments over 3 years. When they failed to complete payments, SITI sent letters demanding payment within 5 days, and later declaring the contracts to sell cancelled. The spouses refused to vacate the property, leading SITI to file an ejectment case. The SE ruled that while a seller may cancel a contract to sell under the Maceda Law on its own without going to court, it must still comply with Section 4 of the law, which requires number 1, a 60-day grace period for the buyer to settle overdue installments counted from the date the installment became due. Number 2, a notarized notice of cancellation from the seller. And 3, cancellation only after 30 days from the buyer's receipt of the notarized notice. In another case, the SC has ruled that only injured or aggrieved spouses can ask the court to nullify their bigamous marriage and guilty spouses cannot do so. The SC en banc, through the ponencia of Associate Justice Ricardo R. Rosario, denied a Filipina's petition to declare her second marriage void for being bigamous. The petitioner had married a Chinese national in Hong Kong and in the Philippines, and later married a Filipino when she came back home. The first husband secured a Hong Kong divorce decree, which was recognized by a Parañaque court. After 14 years, she and her second husband separated. In her petition before the SC, she argued that since her first marriage is already annulled and her first husband had already passed away, she is now the only party who can file the petition to void the second marriage. The SC denied her petition, emphasizing that the purpose of invalidating a bigamous marriage is to protect an existing legal union, not to end it. Since her first marriage had already ended, there was no legal union to protect and no reason to dissolve her second marriage. Article 35, Paragraph 4 of the Family Code states that bigamous marriages, or those entered into while one party is still legally married to another, are invalid from the beginning. Under the rule on declaration of absolute nullity of void marriages and annulment of voidable marriages, only the spouses may petition to invalidate a void marriage. Such spouse must be the injured or aggrieved spouse, as clarified in the rationale on annulment of voidable marriages and declaration of absolute nullity of void marriages, legal separation, and provisional orders. Meanwhile, Chief Justice Alexander G. Gesmundo led the Philippine Judiciary Delegation to the 2025 Pacific Judicial Conference from February 9 to 12, 2025 in Auckland, New Zealand. He was joined by Supreme Court Associate Justices Ramon Paul L. Hernando, Rodil V. Zalameda, Mario V. Lopez, Samuel H. Garlan, and Jose Maidas P. Marquez. During the conference, Justice Marquez discussed the benefits and challenges of technology, including the role of artificial intelligence, or AI, in the work of the Philippine judiciary. Titled Strengthening the Institution of the Judiciary, the conference gathers judiciary leaders from 15 Pacific Island nations, Singapore, Australia, the United States of America, and the United Kingdom. The Supreme Court, led by its Committee on Gender Responsiveness in the Judiciary, or CGRJ, also held a kickoff activity on Monday in support of the 2025 1 Billion Rising Global Campaign, reiterating its commitment to ending all forms of violence against women, or VOW. Themed Rise for Freedom, a short program was held after the flag-raising ceremony. Acting Chief Justice Marvic M.B. Leonen and CGRJ co-chairpersons Associate Justice Henry John Paul B. Inting and Associate Justice Josep Y. Lopez delivered inspirational messages encouraging SC officials and personnel to speak out and do their part in helping fight violence against women. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.